Division Bench Item 1 for orders. IS Civil 1049/2026.
माफी के लिए आई थिंक तो माफी के लिए
5 days.
395%.
What is the good ground?
So ground I have mentioned page number 5, para number 2, Your Lordship. So initially, Your Lordship, there was a communication with the learned counsel, earlier engaged counsel, Your Lordship. So thereafter, Your Lordship, despite persistent communication, Lordship, did not inform even after Your Lordship final disposal of the requisition, Lordship. Finally disposed of on 20/12/2024, Lordship. So therefore, there is a delay of 395 days, Your Lordship. And also there is a High Court judgment, Your Lordship, in review petition, Your Lordship. Limitation not necessary, Your Lordship.
Here latches will apply. Here latches has equal application. Can't
So-
review after 395 after a year and then say that that's to be condoned. There's no explanation here.
Explanation will be Lordship only restricted to that particular point, Your Lordship. Because Your Lordship, I was totally, Your Lordship, not conversing with the fact, Your Lordship, regarding the final disposal of the case. Earlier, I had communication, Your Lordship. So thereafter, Your Lordship, what happened, Your Lordship, despite repeated communication, Your Lordship, we did not inform about the final disposal of the case, Your Lordship. So therefore, on my own, Your Lordship, on 29/12/2025, Your Lordship, page number 6, the order which was delivered on 8/1/2026, Your Lordship, and the applicant therefore consulted with the new counsel at Gauhati, and as per instruction of the learned counsel, they have handed over the brief for filing the present review petition accordingly the instant review petition filed on 27/02/2026, Your Lordship. So there is no lapses, Your Lordship, no deliberate and willful negligence on the part
Just a
of.
minute, just a minute. Yes, Ms. Verma.
Lordship may condone the delay, and here they hear it on merit, Lordship.
Merits of the review.
As it is, Lordship, grounds taken are the, it's already discussed in the petition order, Lordship.
That the one that had counsel for the petitioner and so and so for the applicant and so and so for the respondents. Yes. By filing this interlocutory application, the applicant who is the review petitioner in the connected review application paid for confirming the delay of 395 days beyond the period of completion in filing the review application. The ground for the reasons assigned for controlling the delay is not at all satisfactory. There's the issue of citizenship is involved. What is it? of the considered opinion that the matter we heard on very accordingly the delay of 395 days beyond the period of limitation is hereby controlled. Registry shall use the connected review petition and it is the same thereafter.
Not so less. I appear for the petition.
Just wait for a moment. Every time we take up other matters. Yes. That is
Lord, I am for the petition.
when, but you have not issued notice here. Then
some time to obtain the instruction.
you've been given sufficient time. The last order was passed on 6/4.
What instruction I have received is not complete also.
No, they will never give you a complete instruction.
And moreover, vetting is also.
You'll have to permit us to impose cost on the officials. Then you will find it tomorrow, they will give you. Don't it like that. This leads to misappropriation.
Yes.
Who's going to give you instruction? Nobody is going to give you.
Nothing I grant some time. So then I can find my answer.
Is a representative. The allegation made in this PIL is regarding misappropriation of government funds allocated under MG Narega. The matter was twice adjourned on 9/1/2026 and 26 and 6/4/2026. So H. Chandran, our government advocate, is for some kind of filing affidavit. Next one. In light of the allegations made in the PIL, the adjournment without issuance of notice in the matter is not desirable. Therefore, it is provided that in the event affidavit by the state is not filed, state respondents is not filed, it is 1 day prior to the next date of listing, the court would draw adverse inference by invoking the doctrine of non-traverse and proceed to hear the matter on the basis of motives available on record. Next paragraph. Affidavit shall be filed by 5/8/2026. Next by list on 7/8/2026.
Obliged.
For that you say that the additional senior government advocate shall send a downloaded copy of this order to the state respondents to bring the order to the notice of the said authorities.
My lord,
Item number 13, commission matter number first time after the continuation of DD
Item,
need to file a copy
item,
13 miles for corporation of
2 weeks. Both sides are represented on the claim made by the learned counsel for the appellant to matters subject John today. List on
10 from
19th.
or on 24.
19th. Yes,
my lord, I beg to mention for listing the DB1 matter, my lord. Let it come on day after tomorrow, your lordship. I filed it on 20th of July. Yeah. Okay.
2.
Some development has been given to both the parties, AEP or for but it was not agreement with the consent.
Have they arrived at a, some discussion is going? They have held a meeting.
Discussion is going.
Item 2, both sides are represented. It has been submitted that the petitioner and the respondent numbers, you have respondent numbers.
2, 3, and 2.
2, 3, and 4 are negotiating settlement. Are negotiating the matter. So accordingly, matters from John today. List. Okay. Due date after 2 weeks. List on specific.
May I please, your lordship? My lord, with regard to item number 9, my lord, I filed a affidavit in operation. Today, for the matter today, my lord, that affidavit may kindly be brought in. I filed a requisite slip.
Lordship, with regard to item number 70 of this list, Lordship, we have circulated an adjournment slip, Lordship. I appear for the respondent. The difficulty being that Mr. Chaudhary is out of station, Your Lordship. May I put a matter may come on Friday, Your Lordship, 31st.
17th.
17th.
Lordship, I am appealing for the NHPC applicant. Lordship, in this case, I am being led by Mr. Gaurav, Senior Advocate Gaurav from Supreme Court. He has sought for a date for on Thursday, so probably there will be a difficulty. Let me listen on Friday.
Friday, Lordship, 31st.
Item 17.
17th.
17th.
April 17. Which is represented on the they are made by Mr. Gautam, the counsel for the respondent. Number 1, the matter streams of John today. Agreed to by both sides. List on. We could Friday.
31st, Your Lordship.
31st.
Obliged.
May I please, lordship? Lordship, I beg to mention item 22, lordship. On last occasion, lordship have passed an order for filing an IA for striking out for respondent number 11, lordship. So we will file our IA today in itself, lordship.
Your name?
P. Ragha, on behalf of Ms. A. Garin.
P.
Ragha.
Is P. Ragha, Learned Counsel, appearing on behalf of the Learned CGC. Submits that an interrogatory application is being filed in course of the day today. Magistrates are joined today. List adjournment, the said interrogative matter is fine.
May I please, Lordship?
List along with the said interrogatory application. Yes.
May I please, Lordship, I beg to mention item number 14, my lord. An adjournment slip has been circulated, my lord. A criminal is from personal difficulty to there.
14.
14, my lord. Angela, wait, my lord.
It says a representative of the prayer made by the counsel for the petitioner. List on. Due date of 2 weeks.
Obliged.
Item number 10.
Item 10.
Anybody appearing for respondent numbers 2, 3, 5, 6, and 8? Anybody is appearing for 5? No. Five is normally CGC should appear.
Yes, sir.
Then you are not appearing for respondent number 5?
Okay. Well, eight. My lord, I am appearing for 8.
No, you are asking for 5.
Right.
You are not appearing for 5. But this is central government.
They are separate council, my lord.
Central Administrative
This is not central administration. TN accounts of it.
One talukdar, my lord.
Respondent number 5 are represented. Who's praying for adjournment?
My lord, I am, my lord, respondent 8, man. My lord, I have prepared my affidavit and sent for vetting, and same has been forwarded to principal bench, New Delhi, my lord. That not yet received that, my lord, by me, my lord.
Mr. P.S. Bhattacharya and council correspond by 8. Submits that the affidavit in opposition has been sent for vetting and signature. Accordingly, pays for adjournment and is allowed. Affidavit shall be filed at least 2 days prior to the next date of the stream. Next one is done. You will take after 2 weeks.
Hello. Problem.
For motion item 3,
The impugn order is at page 89, Lordship. This is a contested case. 89, Lordship. Opinion dated 23/6/2026, Lordship.
item 4,
Maybe it will also. Maybe it will also. here we have challenged the order passed by the Honorable Central University Flight. Lordship, yes. Lordship, your Lordship will kindly see, we were granted intercommissioner transfer in the year 2017. Now, Lordship, thereafter in 2022, we have been stated that the intercommissioner transfer was not applicable to us because, Lordship, the new rules, the rules framed in 2015, did not contain an absorption clause. And therefore, we were sought to be repatriated. That was the only reason why the ICT which was granted to us was sought to be revoked. Now, Lordship, our contention before the Honorable Tribunal was that the erstwhile rules, the 2003 rules, did not also contain any absorption clause. Now, under the communication, if your Lordship kindly comes to page 8, Lordship, that's page 74. Page 74. May I read from the second paragraph, Lordship? This is a communication dated 27th October 2011. May I read it? From the second paragraph, Lordship. On consideration of all aspects in the matter of ICT, Lordship, I am from Group C, Lordship. C. Lordship. Lordship will kindly see. Lordship, my initial joining was Group C, subsequently promoted to Group B. Now, your Lordship will kindly see paragraph 2. On consideration of all aspects of in the matter of ICT, it has been decided by the board now to lift the ban on ICT with immediate effect. Accordingly, any Group B, Group C employee and as well Group D employee may apply for transfer from the jurisdiction of one cadre controlling authority to another cadre controlling authority, subject to availability of vacancy and on the following terms and conditions. Your Lordship will see, first condition, the concerned two cadre controlling authorities should agree to the transfer. The transfer will be placed below all officers appointed regularly to that post/grade on the date of his or her appointment on transfer basis. Second, on transfer, he or she will not be considered for promotion in the old commissionerate. And your Lordship will see, under these two conditions, that I lose my promotional revenues in my old commissionerate and the seniority, we were granted intercommissioner transfer in the year 2017. That your Lordship will find at page 76. (76) is for the petitioner number 1, Lordship. 77 for 2 and 78 for petitioner number 3. This was during the period of 2017 to 2018. Now, your Lordship may kindly see the impugned order, Lordship, at page 33. Page 33, Lordship. Annexure A3. May I read that? Subject ICT in the layout of EA, executive assistance in light of orders of EA. I am directed to refer to the board's direction of event number dated so and so, wherein the direction to maintain status quo in respect of ICT is carried in EA cadre till date until the matter of ICT of inspectors reaches finality were issued. Now the matter in SP Naushad Rahman's case of so and so has been decided by the Honorable Supreme Court by its judgment dated 10/3/22. By this judgment, the Honorable Apex Court has upheld the judgment of the Honorable Kerala High Court. Inter alia has left it open to revisit the policy to accommodate posting of spouses, the needs of the disabled and compassionate grounds.
In view of the above, the direction to maintain status quo are hereby withdrawn. Wherever ICTs were affected in EA cadre, the same not being permissible, CCS shall treat such ICTs as deemed on basis in terms of board circular dated 29/2018. Now, this board circular, your lordship will find this at page 144, lordship. The petitioners are executive assistants, lordship.
Which ground?
Lordship, I am assailing this order on the ground that
No, you are seeking transfer on which ground?
no, lordship, I had not sought transfer. Intercommissioner transfer was granted to me in 2017. Now
Okay,
we are
without your applying.
no, we had applied, lordship. We had
Sorry, on what
on
ground?
family compassionate grounds, lordship.
Yes.
Now your lordship will kindly see the circular which has been relied upon. That is at page 144. May I read, lordship? This is a circular dated 29/2018. The impugned order relies upon this circular to repatriate us to our parent zones, lordship. Your lordship will see the subject. This was issued with respect to inspector. May I read it, lordship? These instructions are being issued in terms of Central Excise and Custom Commissioner Inspector, Central Excise Preventive Officer and Examiner, Group B, Post Recruitment Rules 2016. We are executive assistants. We are not covered under the said rules. Now, your lordship will see why this circular was passed. Lordship will kindly come to paragraph 4, the relevant part, lordship. May I read? The ICT applications were considered under Rule 4 of the erstwhile Central Excise and Land Customs Inspector Rules 2002, which stated, Rule 4 special provision. Each cadre controlling authority shall have its own separate cadre unless otherwise directed by the Central Board of Excise and Customs. Now the next part is relevant, lordship. Page 145, subplus 2 at the bottom, very top, lordship.
Page number?
Page 145, lordship, the next page. At the top, lordship. Notwithstanding anything contained in Subrule 1, the jurisdictional chief commissioner of Central Excise may, if he considers to be necessary or expedient in the public interest to do so, and subject to such conditions as he may determine, having regard to the circumstance of the case and for reasons to be recorded in writing, order any post in the Commissioner of Central Excise to be filled by absorption of persons holding same or comparable post but belonging to the cadre of another commissioner or director under the Central Board of Customs. The next part, lordship. However, under the Recruitment Rules 2016, the corresponding provision containing the special provision under Rule 5 provides that each cadre controlling authority shall have its own separate cadre unless otherwise directed. From the above, it is clear that the recruitment rules of 2016 do not have any provision for recruitment by absorption, and accordingly, no ICT can be considered after coming into force of the recruitment rules 2016. Now, lordship, in the case of inspectors, under the earlier rules, there was an absorption clause. 2016 rules, that was done away with. Therefore, the board came to a conclusion that since the 2016 rules does not contain this absorption clause, ICT cannot be granted. But lordship, in respect of the executive assistants, the earlier rules, if I may take your lordship to the earlier rules also did not have any absorption clause. The new rules, there is only a redesignation of the nomenclature. The rules are exactly the same. There is no absorption clause. Persons who were granted under the earlier rules in 2012-13, they have not been touched upon. ICT granted to them under the 2003 rules, wherein there was no absorption clause in terms of this 2011 letter, they have not been touched upon. 2016, they are seeking to repatriate us, stating that there is no absorption clause. That was the position even in the earlier rules. Therefore, my humble submission was that we are not similarly placed as the inspectors. I am on the point of discrimination. You are treating similarly situated persons in a different manner.
No. That's what is being clarified.
Lordship.
Even the tribunal has referred to it.
Lordship.
You see, you were not transferred pursuant to the in accordance with the policy.
Lordship.
Because this family compassionate ground which you are saying
Lordship.
is not the ground. It was on based on two things. Number one, if the spouse is posted somewhere, then to accommodate you to be with the spouse, then you are being transferred. And the second ground was
Lordship.
But you said that you are family compassionate.
Lordship,
That means somebody in your family is ill or something,
Lordship.
or aged parents, that is the ground. If that is not covered by that policy,
No,
so
Your
it's not discrimination.
Your Lordship will kindly see the policy at page 74. Wherein the ban on intercommercial transfer was lifted, page 74, Lordship. First paragraph, last line. This was, may I read it, Lordship? This was done.
You see, it was relaxed in phases on spouse ground,
Lordship,
compassionate appointment ground, and physically handicapped employees.
Lordship.
These are the three reasons for lifting the ban.
Lordship.
You don't fall in these three
But now,
categories.
Lordship, Your Lordship will kindly see the impugned order. The ground which all authorities have taken is the 2000, they have not taken this ground, Lordship.
Yes, it is. You are reading us page 145.
Lordship. That is in respect of Lordship inspectors. And the,
Whatever be, you have shown us this.
Your Lordship will kindly see paragraph 5, why that order was passed. The reasoning therein, Lordship. 145, paragraph 5. From the above, it is clear that recruitment rules 2016 do not have any provision for recruitment by absorption. And accordingly, no ICT application can be considered after coming into force of the recruitment rules 2016. Therefore, the ground was that, Lordship, under the 16 rules, there is no absorption clause. Therefore, after the rules, ICT cannot be granted.
Correct. In 6, it says in
Lordship.
exceptional circumstances, depending on the merit of each case,
Lordship,
such as extreme compassionate grounds, such
Lordship.
transfer may be allowed on case to case on loan basis.
Lordship,
So it's very clear that you had your problem with someone in the family or some compassionate reasons.
Lordship.
They are accommodating you on loan basis, and therefore you go back to your department.
Lordship, this order was issued subsequently after ICT was granted to us. ICT granted to us in 2017. This order is passed on 20th of September 2018 in respect of inspectors. We were already granted ICT prior to that. This came only subsequently. This was issued subsequently, Lordship. When we were transferred, Lordship, the 2011 circular was in existence. Lordship. Lordship, therefore, my case is because the only Lordship. Lordship circular. Lordship, the circular is at page 2017, 2011, page 74. Policy. Lordship, my transfer orders, your Lordship will find at page 76 to 78, Lordship. Lordship, the order of the tribunal, Lordship, before your Lordship comes through.
Page
May I
one
check?
93, Lordship. It starts with page 193.
Page 193 starts, your Lordship will see the Honorable Tribunal relied upon two decisions, that is at page 200 and page 201, to arrive at a finding that since the matter has already been decided, Lordship, this, if I may just place these two decisions, both these decisions were passed in respect of inspectors. Those were, Lordship, I am referring to page, your Lordship will kindly see, of the judgment, Lordship. Lordship will kindly see. Lordship will kindly come to page 200. Page 200, paragraph 11. The Honorable Tribunal had relied upon two judgments, Lordship. Gulshan Kumar, passed by the Honorable High Court of Kerala, and the order dated at paragraph 12, order dated 14/5/2026, passed by the Honorable Tribunal in OA 170 of 2023. And therefore, Lordship, in the penultimate paragraph at page 203, the Honorable Tribunal came to a finding that since the similar issue has been dealt with, we are not inclined to pass separate orders. Now, your Lordship has placed those two judgments. If your Lordships kindly see, both the judgments were passed in respect of inspectors. And this circular, which I had taken your Lordship through 2018 circular, that was issued in respect of inspectors, made applicable to the executive assistants only in 2022 by the impugned order. We were granted ICT in the year 2017. 18 passed in respect of inspectors, made applicable to us in 2022, and which were already granted to us were sought to be taken back by retrospectively applying the circular, Lordship. And the Honorable Apex Court in S.K. Naushad Rahman's case, that was also pertaining to inspectors. Because the only ground which the authorities have taken is under the new rules, there is the absorption clause. Rightly so, Lordship, in respect of inspectors, earlier there was, subsequently that was withdrawn, and accordingly ICT, it was stated that ICT was applicable. But for executive assistants, both the earlier rules and the new rules did not contain absorption clause. The persons who were transferred prior to coming into effect of the new rules have been allowed to continue, even though there was no absorption clause. Now, only persons who were transferred after coming into effect of the 2015 rules are now sought to be reverted back. And Lordship, another aspect. Lordship, the applicant number 1 and 2, both of them, 2017, they were promoted, granted ICT, Inter-Commission and Transfer, Lordship. 2019, the authorities say that the promotion was wrong, he will be reverted back to tax assistant. That subsequently the Honorable Tribunal upheld the order. Now, Lordship, under the tax assistant, assuming for a moment, Lordship, that executive assistant ICT is not applicable, Lordship. Lordship, under the tax assistant, the ground which they have taken, that absence of absorption clause, under the tax assistant, the absorption clause still remains. Therefore, if not for that erroneous promotion, which was subsequently taken away by them, I would have still continued as tax assistant, wherein absorption clause was there, wherein ICT would have been granted. Assuming for a moment that in EA it cannot be granted. Because their only contention is that absorption clause. Tax assistant, I have enclosed the rules, Lordship, of 2014 at page 224, that contains the absorption clause. That was the only point on which the circular was passed for the ES, that there is no absorption clause. Now, Lordship, the authorities grant me a promotion, then they say that the and then they grant me ICT, and then they say that the promotion is wrong, we will revert you back. and then they say we had granted you ICT in the promoted cadre, we will take back your promotion, we will also take back your ICT. By retrospectively applying a circular issued in 2022. My Lordship, can that be allowed? And persons who were granted earlier have been allowed to continue, even though there was no exemption clause. That is the sum and substance of my case, Lordship. And the petitioner number 1. Lordship. 2018, Lordship. (145), Lordship. Lordship. Lordship, yes. Your Lordship, kindly see paragraph 7 of that circular. That was in respect of inspectors, Lordship. Paragraph 7 makes it clear. Now, therefore, it is clarified that an office order for intercommissioner transfer in the grade of inspectors issued on or after 26/12/2016. Lordship, we are executive assistants, Lordship. Executive assistant. Lordship, this circular was made applicable to us by page 33 in 2022. This was issued on page 144, your Lordship will see that was only in respect of inspectors. There is no reference anywhere for executive assistants. Page 33 for the first time that is made applicable to us in 2022.
Lordship, may come to page 198, para 5, what we have stated before the CAT, Lordship. Page 198, para 5. Lordship is there. Respondents have filed their written statement and stated that against the establishment order number. Respondents have filed their written statement and stated that against the establishment order number so and so, dated so and so, applicant submitted representations and filed OA number so and so in terms of the order of this tribunal dated 10/6/2022, passed in OA number 121 of 2022. They dispose of the representations of the applicants by speaking order dated 29/7/2022. As per the respondents, there is no policy regarding issuance of notice while complying with the board's instruction, as the applicants were terminated, but very much continuing their service and were transferred in terms of the board's letter dated 22/4/2022. The policy relating to ICT in the grade of EA attains finality, and irregular cases are liable to be rectified as per board's instruction. All the formation of the CBIC are bound to follow board's instruction, and this zone issued establishment order number so and so, dated so and so, which converted the ICT tenure of the applicants as deemed loan posting and relieved on completion of the loan tenure. Then Lordship at para 6, against the written statement.
No, what do you intend to say with that? You say the applicants were terminated. Then you say they were continuing service.
Lordship.
It's contradictory. How do you sustain these two things together? How can somebody be terminated and then continue in service? Is it possible?
No, Lordship.
Terminate someone and then continue in service? Something is wrong. And where is that establishment order of 25/5/22?
Lordship, there is a page 31, Lordship.
31.
31.
From it, no, I repatriated, repatriated. Mistakenly, he said. No, no. Not in the repatriate, could you say? Could you say it again?
Repatriation. Worship. Worship orders in
The charter of
2022, Lordship. Lordship. So 22/4/22 is referred to page 33, the wherein that circular of 2018 was made applicable to the ES. Because the 2018 circular was only for inspectors. That was made applicable to executive assistant by this letter, Lordship, page 33. 22/4/22. There is no exercise to that effect. Straight away, this order at page 33 was passed, Lordship. Straight away, this order at page 33 was passed. Lordship.
not.
Lordship. Also representation, your lordship will find page 79. That was disposed of by the MP on placing order, lordship. Lordship, the MP on order, your lordship will find taking order, page 28. The relevant is at page 29, lordship. Your lordship will kindly see the only ground taken was that there is absence of absorption clause. Lordship. Lordship, yes. Lordship, yes. Lordship, but your lordship will kindly see that relies upon the 2022 circular at page 33, lordship. Page 33 again goes back to 2018 circular, wherein the only reasoning was absence of absorption clause. Their contention was that in the circular, that since there is no absorption clause, ICT cannot be granted. Lordship, yes. Correct. Your lordship will kindly see, will treat such cases as deemed loan. Lordship will kindly see the circular of 29, 2018. Your lordship will kindly see EA in the EA carrier was not permissible. Lordship, there has to be a reason for that. That reason they have assigned to 2018 circular. There has to be a reason for that, Lordship. 2018 circular states absence of absorption clause. If that be the case, absence of Lordship, yes. Lordship. Lordship. Yeah, Lordship. Lordship, yes, Lordship. Lordship, ICT, your Lordship will see, I understand the contention of the respondents that ICT in the category of A is not permissible. Lordship, there has to be some reason why it is not permissible. That reason has been assigned in. No, your Lordship will kindly see, they have relied upon the circular of 2018. That is the reason by the authorities. That is their stand, Lordship, in this circular. Will be treated as dream loan in terms of both circular dated 29 2018. 2018 circular says absence of absorption clause. That is the only point. And they have not stated anywhere other than that, other than the circulars, except for that absorption. And even if your Lordship takes up the written statement, in each and every paragraph, the only statement is absence of absorption clause. Therefore, ICT is not applicable. In each and every paragraph of the written statement. That is the only ground taken. Lordship, that is at page 28, the speaking order, Lordship. 28. Lordship.
Lordship, Lordship, this ICT is not applicable in EA cadre, Lordship, which is already stated in page 29. Lordship, wherever ICTs were affected in EA cadre, the same is not permissible. GCA shall treat such ICTs as deemed loan cases and subsequently at paragraph 4 has directed to take all necessary actions may be taken in line with the instructions. Lordship. Page 29, Lordship. First para, Lordship.
Lordship, at page 155. That is at page, Lordship, 144. This was in respect of the inspectors. Your Lordship will kindly see the written statement, page 155 for a moment. 155. They have explicitly stated why ICT in EA is not applicable. Page 155, Your Lordship will see for executive assistant. ICT is not applicable in the grade of executive assistant as the method of absorption is not included in the special provision of the recruitment rules of 2015. Your Lordship, that is. Lordship. Lordship, yes. Lordship. Lordship. Lordship, my only submission in that regard is the earlier rules in respect of executive assistant also did not contain any absorption clause. They have granted ICT under the earlier rules. They have allowed them to continue till date. They have not been repatriated under this guise of Lordship. Lordship, that trouble I have. Lordship, but they have only applied this absorption clause only in respect of the recruitment rules of 2015. They have not applied it to the earlier rules. And the Lordship will also consider the second aspect, wherein promotion was granted to us. We were granted ICT. Lordship. Lordship, because we were granted promotion, then ICT. Now, in this page 153, they themselves admit that ICT was applicable in the cadre of tax assistant.
You see, what happens is, you ask for a transfer, you are given a transfer. Therefore, your ACRs would not be maintained in the parent department. Now, without that ACRs, how do you consider you for promotion? Therefore, you lose out in that manner. You see, deputation, if it's a deputation, then those authorities will write it. But yours is not a case of deputation, you are transferred. And then it is found out that you couldn't have been transferred. So at best, you can agitate that if you will leave it open to you for agitating that, but you don't have a ground.
Because that 2000.
You see, if I have not maintained your ACR, I would not be able to consider that for the purpose of promotion.
Now, the 2011 circular, that stated that I will be assigned bottom seniority in the cadre wherein I am transferred.
Transfer itself is not permissible.
Lordship, that came up subsequently. But your Lordship will kindly see the second aspect. Tax assistant, they promote me, they grant me ICT, and then they revert me back to tax assistant. And then they admit in their own written statement that ICT was applicable in the cadre of tax assistant. Now, Lordship, there is no hand. I cannot grant myself promotion. The authorities granted me promotion. Then they found it to be erroneous in 2019. Then they take away my promotion. Therefore, I am reverted back to the tax assistant cadre. Now, but for that erroneous promotion, Lordship, I would have continued in the tax assistant cadre. And page 153 in the written statement, they themselves admit that ICT is applicable for tax assistant at the relevant point of time.
We leave it open, we don't.
You were promoted to tax assistant.
Executive assistant.
Retrospectively, you were reverted. Did
Lordship,
you agitate this?
Lordship, tax assistant, I was promoted to executive assistant. They
Sorry, tax.
2019,
And then retrospectively, you were reverted back.
2019.
So when you were reverted back, did you agitate?
Lordship, yes, that honorable tribunal came to a finding in 2024-25 that the reversion was correct because under the new rules, the residency period was 10 years. But since we have continued for this long, they were directed to reconsider our case, consider our case for promotion. But we were reverted back, that reversion was upheld by the honorable tribunal. Now, for that 1.5 to 2 years in between, I was promoted, I was granted ICT, and then again reverted. And in the tax assistant cadre, ICT was applicable because for me, the primary concern was to come back to my family. If I would have continued the tax assistant, ICT would have been clearly applicable. But for the erroneous promotion, that was done away with. And Lordship, presently, the petitioner number 1 and his wife is undergoing procedure for your Lordship will kindly see this one. Okay. At this stage, if they are repatriated back, it will be also great prejudice to their family life, Lordship. They are undergoing treatment and procedure for
Benefit of promotion.
Lordship. I'm sorry, Lordship. That is the influence that's in Lordship at page 193.
193,
Right.
where is that reference to the challenge made for your made against your reversion?
Lordship, that your Lordship will find that page 49 of 2019, Lordship. That your
Page?
Lordship, that is at page 214, Lordship.
214.
Lordship.
That is another order.
Lordship, another order that was passed in 2025. Because
But then this order is not under challenge.
No.
No, Lordship.
Then we can't even give you the benefit of that.
Because Lordship, herein, even though that was set aside, appeal, ultimately the Honorable Tribunal came to finding that you considered their cases again. The relevant is at page 223, Lordship. This was a reversion occasioned in 2019. And the repatriation occasioned in 2022.
223 direction also. And where is the order after this, page 223? Any orders of the
No,
department?
Lordship.
दिया नहीं go back one minute. There is not our subject matter.
That is not annexed here, in 223, 223 is correct. Correct.
A. Chakravarti, learned counsel for the petitioners, and Mr.
Age and of the.
A. Jain, learned counsel, appearing on behalf of Mr.
Okay,
Okay,
for
on
2
behalf of
and 3,
Mr.
on behalf of Mr. STKL for respondent number 2 and 3.
STKL, learned standing counsel for respondent numbers 2 and 3. And you are for?
Respondent number 1.
Okay. Uh, And Mr. Again, Mr. V.K. Chopra, and then CGC for respondent number 1. Yes, you have anything to say? Hmm? Pardon me?
They relied on our permission.
Okay. Okay. By filing this repetition on Article 226 of the Constitution of India, the petitioners have assailed the order dated 15/7/2026, passed by the learned Central Administrative Tribunal, Gauhati bench, by which OA number 042/00176/2022, page 193, was including interlocutory applications therein were dismissed. Next para. Next, the case of the petitioners is that they were appointed as tax assistants at the Mumbai Commissionerate of the Central GST and central excise okay. No, 1 and 2. And now, and petitioner number 3 was appointed as the tax assistant in the Vadodara, in the central GST and central excise, Vadodara zone on 13/12/2013 and 7/2/2014 respectively. Full stop. The petitioners applied for their transfer for intercommissionerate transfer within bracket ICT for short to Shillong Commissionerate. Full stop. The representations were accepted by the respondent authorities and accordingly, by separate orders dated 18/12/2017, 18/10/2018, and 16/8/2017 respectively, transferred the petitioners to GST and Central Excise and Customs Commissionerate at Shillong. Full stop. All three of you joined as
Tax assistant.
assistants.
Initial appointment as tax assistant, subsequently promoted as executive assistant.
Okay. No, when you came to Shillong Commissionerate, you were appointed as tax
Executive assistant, Lordship.
executive inspector.
Lordship, that promotion order, the Lordship will find. That is at page 69 to 7. 69 is for 1 and 2.
69,
69, Lordship.
59.
Page number 69, Lordship. Petitioner number 1 is at serial number 17, Lordship. And petitioner number 2 is at serial number 15. 1 is at 17, Lordship. And and for petitioner number 3, the order is at page 71. His name is at Lordship, serial number 44.
ये तो शाही प्लेयर और कोई बोलेगा ये तो अबे बस सो इतना था 1617 from his order तो ये तो 1617 20 मतलब कोई से तो executive assistant से transfer करो सर okay no don't say that first we said about the 3 posting then you say thereafter by a promotion order dated 1/6/2017, the 3 petitioners herein were promoted to the post of executive assistants on regular basis by establishment ESTT, establishing office order number 182/2017, dated 1/6/2017. Full stop. Thereafter, the transfer orders of number 1 on 18/12/2017. Number 2 is 18/10/2018, and then number 3 is 16/8/2017. To stop accordingly, the petitioners joined the Office of the Chief Commissioner of Central Goods and Service Tax and Central Excise at Shillong as executive assistants. Next paragraph. The learned counsel, next paragraph, the learned counsel for the petitioners state that the respondent authorities by an order dated order number 35/2022 dated 25/5/2022 amongst others, declared the petitioners to be treated as the transfer of the petitioners to be treated as loan posting, and accordingly directed their repatriation to the parent zone. And accordingly, the petitioners were treated as relieved with effect from 31/5/2022. To stop. Accordingly, the petitioners had submitted their representations respectively on 26/5/2022 and 27/5/2022. So the same were not considered by the respondent authorities, and accordingly the petitioners approached the Central Administrative Tribunal, Gauhati bench by filing OA number 042/0049/2019, page 214. Full stop. The in connection with this said original application, the learned Central Administrative Tribunal, Gauhati bench dispose of the same by order dated 26. What is the date of this order?
Lordship, the 26/6/2025.
26/6/2025. So the operative part of the said order is quoted below, page 222, para 12.
I believe the order date will be 18/7/25, page 214, Lordship.
Okay, it is okay. 18/7/25 on the date of order. Full stop. It may be stated that the respondent authorities by a speaking order dated 29/7/2022. Held that the petitioners were in the grade of executive assistants and in light of the recruitment rules regarding executive assistants, which was notified on 28/9/2015, by referring to paragraph 3 thereof, held that wherever ICTs were affected in executive assistant cadre, the same is not being permissible, and accordingly the what is CCA?
Cadre controlling authority.
Cadre
Controlling authority.
controlling authorities shall treat such ICTs as deemed known cases, and accordingly the as per the said speaking order, the petitioners were directed to follow the direction of this of the office order dated 25/5/2022, issued in terms of the board's order dated 22/4/2022. Full stop. The petitioners were held to have been relieved by the aforementioned order dated 31/5/2022 and were directed to report to their respective parent zones. And and as per the directions of the learned Central Administrative Tribunal, Gauhati bench, their release was relaxed for 7 days of the date of receipt of the said order dated 29/7/2022. Full stop. Accordingly, the petitioners approached the Central Administrative Tribunal, Gauhati bench, and the said learned tribunal by order dated 15/7/2026 passed in OA 042/00176/2022 along with its interrogatory applications. Observe that the policy relating to the ICT in the grade of executive assistant attains finality, and irregular cases are liable to be rectified as per board's instructions. And accordingly, relying on the case of Gulshan Kumar and others, versus Union of India and others. No. No, it will be different. Union of India and others versus Gulshan Kumar and others, comma, capital OP within bracket CAT, bracket close number 173/2018, decided by the High Court of Kerala on 10/4/2019, as well as the case of Sri Khaisonthang, KHAISONTHANG, and others versus Union of India and others, comma, OA number 040/00173/2023, decided on 14/5/2026. I held that the similar issue was already been dealt with by the tribunal as well as by the High Court of Kerala, and the applications were dismissed. To stop resultantly, comma, the said OA number 042/00176/2022, along with the interlocutory applications, were dismissed. Next paragraph. The learned counsel for the petitioners has submitted that both the cited cases were incorrectly applied in the case of the petitioners, and that the distinguishing factor of both the cases were that those were cases relating to inspectors, whereas the petitioners were promoted to the post of executive assistants. First of all, it is submitted that not only the petitioners who were promoted to the next higher post of, they were promoted to the next higher post of,
No, so from tax assistant to executive assistant. From tax assistant, they have been promoted to executive assistant.
after that they are reverting back to tax.
Taxes.
Okay. Though they were promoted to the post of executive assistants, comma, the respondent authorities are now not only reverted the petitioner back to its his original commissionerate, but has also taken away the promotions granted to the petitioners as executive assistants.
So that is in only respect of petitioner number 1 and 2. 3, there is no
Okay,
other.
1 and 2, in respect of 1 and 2 for the post of executive assistants. And without any adverse effect on the respondent number 3
Okay.
with regard to the promotion. Which one? Next part, it is submitted that the petitioners were all having family compassionate reasons which made them apply for the transfer to another commissionerate. Full stop. It is further submitted that insofar as petitioner number 1 is concerned, he and his wife are presently undergoing IVF treatment, which requires them to complete the treatment under this commissionerate. As any transfer may adversely affect the treatment. Next para. It is further submitted that the respondent authorities had relied on the circular dated 29/2018 regarding ICTs for the purpose of denying the petitioners their transfer which had been actuated. But the said circular dated 29/2018, were in respect of the cadre of inspectors and did not concern the executive assistants. Anything else you wanted to say? Page 33 you referred.
That should be.
That is in what context you had said to that?
Page 33, that 2018 circular was made applicable to us.
Pardon me?
So by this page 33 letter of 22, the 2018 circular of the inspectors were made applicable to us for the executive assistant.
So moreover, comment is submitted that while the office order dated 22/4/2022, comma, based on the based on the recruitment rules of the executive assistants, comma, which were notified on 28/9/2015, comma, the respondent authorities treated the petitioners as deemed loan cases in terms of the board circular dated 20 September 2018. Stop. Accordingly, it is submitted that the petitioners have not only been denied of their transfer, their inter-commissionerate transfer, but they have also lost on the seniority and promotion. Full stop. It is submitted that as per the transfer orders, comma, the petitioners were placed at the end of the list of existing executive assistants in the Shillong Commissionerate of the GST and Customs. And accordingly, the petitioners are repatriated back to their original commissionerate, comma, they would suffer greater prejudice. Anything else you have left out?
Only that one aspect wherein if not, but for that erroneous promotion, you would have continued as tax assistant and they've admitted in the return statement that tax assistant ICT is applicable.
Tax assistant?
ICT is intercommissioner transfer is applicable.
Okay.
Only that one.
It is also submitted that had the petitioners remained in their original commissionerate, comma, they would have continued as What is the ST full form is?
Lordship,
No, the ST full form, what is the full form ST?
is
Tax collector.
tax assistant, Lordship.
Tax
TA is
assistant,
tax assistant.
huh?
Lordship, if
STA
that,
is service tax assistant.
no,
No,
Lordship,
no.
Lordship, if that promotion to the executive assistant was not granted to us, we would have continued as tax assistant.
Tax assistant, huh? We would continue as tax assistants. And the respondents in their affidavit in opposition before the Central Administrative Tribunal had admitted that ICT restrictions were not applicable for the tax assistants. And therefore, if the petitioners are treated to be tax assistant by dint of the office orders passed by the respondent authorities, they would be reverted back to the post of tax assistance, and again, they would have been entitled for ICT. Next paragraph. The learned counsel for the respondent must 2 and 3 have referred to the statements made in paragraph 5 of the impugned order and submits that the petitioners were not entitled to be entitled for the inter-commissionerate transfer at the grade of executive assistants, and the said policy retained finality, and therefore the transfer of the petitioners being not in accordance with the recruitment rules, could not have been given effect to. Next paragraph. We'll take a short break. Hold on, right? Hold on. Hold on, right? No, it's okay. We'll continue. Next paragraph. Hold on. Next paragraph. Good. Observation may not be welcome from us. The reason is that if we make that observation, then you lose out the benefit of the order which is there at on 18 July 2025, because you were the tribunal has directed you to be considered for further promotion.
That was
Therefore, we can't make that observation.
Lordship, because that was, we were reverted back to tax assistant, now again to be considered as executive assistant.
To be considered as
Executive assistant, not further promotion, Lordship. Because the tribunal says, in the meantime, we have completed 10 years. Therefore, the residency period for promotion to executive assistant 10 years is complete in the meantime. Therefore, we will be considered for promotion to executive assistant. From executive assistant, it goes to inspector, Lordship, the next promotion. This is for executive assistant.
okay. কোনটো কেটাৰত হ'ব ইয়াত এইটো কেটাৰতে for 10 years মানে কি কৈছে আপুনি নহয় কি কৈ আছে যে মানে টেক্স চিষ্টেমটোৰ পৰা ই পাব এইটো কনচিডাৰ কৰিব বিচাৰে টেক্স চিষ্টেম হৈছে এটি ফটো যদি থাকে ট্ৰান্সফাৰ কৰিব পাৰে কেতিয়াবা ট্ৰান্সফাৰ প্ৰচেছ he can be treated as revert back এসটি কৰিব নোৱাৰে ন আমি এইটো কৰিব নোৱাৰোঁ কাম কৰিছে কিন্তু আমি তাক কমছে কম মানে আমি কনচিডাৰ কৰিব আমি ক'ব নোৱাৰোঁ হিচাপে কাম কৰিছে আমি will be treated as এসটি এইটো ক'ব নোৱাৰোঁ মানে Grade 2 officer grade 2 কাম ক'ব নোৱাৰে যে grade 2 কাম কৰিছে কিন্তু grade 1 grade 2 grade 3 grade কৰে কিন্তু problem নাথাকে bonus আছিলে transfer to bonus আছিলে next paragraph consider the materials available on record the stop. It appears that the Bayan order dated 19/2/2004 passed by the Board of Indirect Taxes. Is Board of Indirect Taxes? Board of Indirect Taxes, comma. There was a ban on intercommissionate transfers in respect of billing officers in Group B, Group C, and Group D posts under the Central Board of Excise and Customs. Full stop. By a subsequent order dated 27/10/2011 under F number, page 74, under F number so and so, the ban on inter-commissioner transfers were lifted. Oblique relaxed in phases on A, spouse ground, B, compassionate appointment ground, C, physically handicapped employees. Full stop. It is due to court facility order to Supreme Court order to Nasim. Nasim Supreme Court order. Where is that order of 94? So it is made to appear that the said orders were passed pursuant to one nine. It's made to appear that the Supreme Court of India in the case of S.K. Nosad Rahman, page 94, and others versus Union of India, civil appeal number 1243 oblique 2022, decided on 10/3/2022. Refer to the decision of the High Court of Kerala in the hearing before referred case of Gulshan Kumar within bracket Supra, and on considering the finding of the High Court of Kerala to the effect that the Central Excise and Customs Commissionate's Inspector within bracket Central Excise, Preventive Officer and Examiner bracket close Group B posts recruitment rules, 2016 do not contain any provision for the ICTs, and to the contrary stipulate that each cadre controlling authority will have its own separate cadre, otherwise unless otherwise directed by the Central Board of Excise and Customs. Affirm the said judgment and left it open to the respondents to visit the policy to accommodate posting of spouses, the needs of the disabled and compassionate grounds. Full stop. Next paragraph. The learned counsel for the petitioners had submitted that the said cases involve the post of inspector and not the executive assistants. Full stop. However, the petitioner being already promoted as executive assistants when they were transferred from the Home Commissionerate to the Shillong Commissionerate, they were the petitioners were holding Group C posts of executive assistants. Therefore, when the High Court of Kerala had referred to the ban in the ICTs for inspectors, it naturally covered the ban on transfer of the Group C posts as well. Full stop. There's nothing which is brought on record, which has been brought on record to show that the recruitment rules applicable for the grade C posts were different from the recruitment rules which govern the cases of the inspectors. Full stop. Therefore, the court does not find any infirmity with the observations made by the learned Central Administrative Tribunal, Gauhati bench that the issue involved in this in the said OA were already decided by the High Court of Kerala in the case of Gulshan Kumar and others using the Supra, and the case of Sri Haison Thang, KHAISON THANG and others using the Supra. Next paragraph. The But whether you said that this, regarding the transfer policies of executive assistants, where is the stand taken in your affidavit?
Statement, Lordship.
Hmm? We don't find it.
Lordship, only one clarification. Lordship, executive assistant is group B, tax assistant is group C. Lordship. Executive assistant is group B, tax assistant, my initial appointment was group C. Lordship.
Okay, it comes reverse from C to B,
C
B
to
to A. Okay, we'll make that correction.
Lordship, at page 155,
155.
under the column for executive assistant.
Next, the consistent stand of the respondents that in respect of executive assistance, ICT is not applicable as the method of absorption is not included in the special provisions of recruitment rules of executive assistants, 2015. Full stop. It is projected that each cadre controlling authority within bracket CCA for short bracket close shall have its own separate cadre, unless otherwise directed by the Central Board of Excise and Customs. Full stop. Therefore, if there is no provisions for the absorptions in the transferred commissionerate, then the appointment to the in the cadre of the Shillong commissionerate cannot be by way of transfer. As each cadre controlling authority is required to maintain a separate cadre. Full stop. Next, therefore, the court is unable to find any infirmity with the impugn order dated 15/7/2026, passed by the Learned Central Administrative Tribunal, Gauhati Bench, Gauhati, in OA number 042 of the 00176 of the 2022. Next para. It is clarified that this court has made has not made any has not examined or made the order dated 18/7/2025, passed by the Learned Central Administrative Tribunal, Gauhati Bench, in OA 0042 of the 00049 of the 2019. Next para. In view of the projection made by the Learned Counsel for the petitioner that the petitioner number 1 is undergoing an IVF treatment. Full stop. In that view of the matter, we leave it open to the petitioner number 1 to make a representation for relaxing of his repatriation in view of the said medical condition, which will be examined by the said authorities in its own merit, without being influenced by anything made, anything stated in this order, anything contained in this order. We'll make that correction.
But till then, the petitioner number one may not be Mr. Joshi. Only
We are not saying that we are permitting you to give a representation
but
for relaxing it.
Not.
but till then, it is because
You make it,
what is it?
the same shall be considered before. We did make that correction. That his reputation may be subject to disposal of that representation.
Obliged.
It's over here, otherwise.
Item 5.
Hello, matter may be passed over for standing.
Supplementary item 33.
Hey, please, your lordship, my senior is coming. Kindly take this matter after some time, you know. Lordship, the 26 order, lordship may issue notice. Lordship, the impugned order is at page 123. Is already seen it. S.E. Murtaja. It will be DCP. Okay. Yes, lordship, DCP body. Lordship, it has to be DCP.
Upgraded item 23 for orders.
Your Lordship, I may be allowed to withdraw this with a liberty. I
Respondent when free, revenue now, no one appears. J. Hendrik.
Item 27 upgraded.
May I please, Your Lordship, this application is filed for seeking modification for grant of extension of time period prescribed by this High Court in writ petition number 943 on 2018. Lordship, yeah, 23, Lordship. Lordship, what has happened, the previous counsel in this matter, after remanding this case, he didn't disclose what happened. He just said that they have to go to the Supreme Court. So for this many years, the petition didn't even know what has happened to this case. We have filed a bar complaint. They have filed a bar complaint. It is in annexure number 3, Lordship.
That is the order of 23. if this is granted, many more of them will keep coming.
But he has filed a bar complaint. He has filed a bar complaint.
Yes, Lordship. And since the matter is remanded back, it ought to have gone at that point of time only, Lordship.
But he's saying that the lawyer misled him, misled her, saying that you have to go to Supreme Court.
If that is a statement which we cannot, it is their statement, Lordship. They have filed a complaint also. He's filed a complaint also. I was just looking into that. Lordship,
No,
because
but
this matter
but
is
still
heard
you see,
it back.
there's another reason why we won't like to interfere. You see, come to a statement made in paragraph 4. In paragraph 4, you say that your lawyer informed you that your case was dismissed and you'll have to go to the Supreme Court. Correct? Now,
No, they said that this case has been dismissed here. and
dismissed,
they
so you have to go to the Supreme Court.
That was the statement that has
I
been given
understand.
by the lawyer to the.
No, that is understood. But did you not ask for the certified copy? You did not take the certified copy even then. When you know that the case is dismissed or disposed of, you don't apply for certified copy, you don't take it.
Okay, this has been happened with that council only.
I
After that,
understand.
they
But you
went,
see, you were informed of the disposal of the case. You don't take certified copies.
So they have to reappear in the tribunal, Lordship.
Even if you accept that, there is a case for disposed of. But still disposed of, you are aware of what has happened. And you see, please look at your statements. You did not say anywhere that you have paid for the certified copy and it was not given it to you. A lawyer may not give you a certified copy at his own cost. What is wrong in that? You don't say that the advocate was required to give you a certified copy free of cost. So you are aware of the order.
we were, they were on a that they have to go to Supreme Court, and that's why they were in touch with that advocate, and he was telling that we are doing.
You see, that is not wrong. That is not totally wrong. You see, you make out a case of interference with the tribunal's order. Matter is remanded back to the tribunal instead of allowing your petition. Allowing to your benefit, that means for the questioning of the setting aside of the opinion of the tribunal. So a lawyer can advise you to go to Supreme Court. What is wrong in that?
But
A remand order may not be taken by the lawyer in a good spirit. He will say that you file an appeal, file a SLP before Supreme Court. What is wrong in that?
this matter was remanded with a.
No, we understand, but everybody may not be happy with the remand order. You would be betting for a total exoneration.
But
Have you not seen any civil appeals filed against the order of remand? Order of remand is permissible. Appeal against the order of remand is permissible. What is the misconduct here?
But this order says remanded back to the tribunal to enable the petitioner to examine the headmaster of Julia High School along with the original school admission and
Correct.
register.
You lawyer may not like that order.
So sometimes
We're not, because of 3 years, we are not very inclined. If we accept what you call explanations like this, it will be work in and work out
The conduct.
procedure of the
They
tribunal.
they gain 3 more years illegally staying here, Lordship.
after some time when my senior.
Come prepared, we will take it up after some time. Mr. Bapatu Bhai, What is your matter? Item
Item 9 of the.
9.
Item 9. It's an appeal by state.
Hmm?
It's an appeal by state.
Sound good.
Like impugn judgment.
But in view of the issue raised, we'll have to issue notice. In view of the issue raised in this appeal, we'll have to issue notice.
Lordship may admit the against they are appearing. Yes.
We'll admit it and
Lordship.
fix it for hearing.
Lordship. For further hearing.
Yes, it will be for hearing only now.
Lordship.
Suggest a date when you want it to be heard.
Well, immediately after 15th of August, subject to your lordship convenience.
And the operation of the impugn order has to be stayed for till
Madam.
then.
I have a prayer for.
The impugn order has to be stayed till then. Or rather, we'll say that discharge orders.
In fact, there are two respondents, the petitioners. One was probationer and one was in regular appointment, regular employment. And in respect of the regular employee, departmental proceeding was conducted. And the probationer was, he was released from service.
Matter 70. 70. Discharge orders.
Hello. Yes, madam. Hello. Well, I have no objection to that, Milan, but the thing is that, Milan, it is already one year is already over, Milan. They have not acted upon that order of the honorable single judge, Milan. Yes, please. Mine. Hello, may I pray that the records of the cases may be called for so that it will be convenient. Record of the other court case and also departmental proceeding case. That will be needed at the time of hearing, Miller, for perusal of the lordship. So this justice can.
Judgment of the criminal court is already annexed in the writ appeal.
But the reports are needed, Miller.
Page 33 in the appeal memo, my lord. Page 33, annexure E. In the appeal memo, my lord.
From the contents of the impugn order, that the learned single judge had called for the records and examined it. Neither the criminal case nor the record of the departmental proceedings were called for. This order does not disclose that. Impugn order at page 55.
Yes, sir.
That does not disclose that the records of the criminal proceedings or the records of the disciplinary proceedings were called for. So whether that would be required at the intra-court appellate stage.
Yes, ma'am. No, I'm just making a submission before lordship will take a decision for that.
No, not that Because the Lawrence single judge did not call for that, and the matter was heard without that. So that means the court relied on the matters available on record. We'll say that if you need anything from those records, you are permitted to file certified copies or before the next date, you can file it. If you require any relevant part of the record. Yes, sir. The Lawrence Senior Counsel for the respondent numbers 1 and 2 pray for leave to file and file additional affidavit, if required, to bring on record materials from the criminal proceedings and the departmental proceedings. This one, the prayer is allowed. If any additional document is required from the record of the proceedings of TADA Sessions Case number 118 of 2020, or from the departmental proceedings, same may be brought on record by way of an affidavit. Which shall be filed at least 2 days prior to the exit of district, etc. This from 27/8/2026.
Till then, all of the in order.
We will pass that order in the interlocutory application. IA for stay. I said that David is discharged. David is 63, he is discharged. What is this application for amendment of the cost title?
Well, in fact, while filing the appeal, only on behalf of the state, none of the appeal was filed, and the SP and the other officers, they were made pro forma respondents. Look, we have said that the officers, SP and other officers under whom the respondent number 1 and 2 served, they may be, instead of making them pro forma respondent, they should be treated as the main appellant.
Then we'll have to first pass an order there. The order of admission will be later on.
But
because technically then this order will not be good. Then strike out that earlier order. That will not be good. You pass an order in IA Civil 52 of 2026. Heard Mr. Ginath and Mr. Dr. Arbakato Goy. Mrs. Esther Goy, counsel for the respondent numbers 1 and 2. Next para. By filing this interlocutory application, the applicants who are the appellants in the who is the appellant in the connected intra-court appeal has paid for transposition of pro forma respondent numbers 3 to 7 as appellant numbers 2 to 6.
No.
So we said that the said authorities are required to be included as appellants instead of pro forma respondents. And that it was due to inadvertent mistake that the said officials were carried as respondent numbers 3 to
pro forma
respondent numbers 3 to 7. That's why. Having heard the learned senior counsel for the respondent numbers 1 and 2, the prayer is allowed. The transposition of the respondent numbers 3 to 7 as appellants in the connected appeal is allowed. That's why. The applicants shall file a amended cost title within 2 working days and hand it over to the AOJ writ appeal section for being incorporated in the in the memo of appeal as well as for updating the CIS data. And thereafter the corrected appeal will be listed in the admission column.
Okay.
That admission will have to be deferred till the cost title is amended.
Lots,
So that amendment order has been
lots.
will be passed over.
Okay, yeah.
We are giving you 2 days time, do it.
I'll
and
do that.
No, admission to not, admission to not.
Apart for our fault, my lord. My lord, the what happened to the petitioner that we have indicated in para 6 and also in 9 also, my lord. What happened to the applicant, my lord? May I read, my lord, para 6, my lord?
You read that the existing council had made us read that.
The applicant stand is that he was never informed, my lord, that the case has been ordered. In fact, the language lawyer was not keeping well, my lord. He was under treatment. But this fact, the lawyer immediately after his, my lord, recovery, he could inform the petitioner or through his junior to the inform the petitioner. That was not done. So, my lord, prayer is, my lord, only granting time to appear again, my lord. He will appear. We want to follow the order of this honorable court.
This has been, Bar Council complaint has been made. Let us wait for the outcome of the Bar Council. Will issue a notice. You tell us about the development of that complaint.
My
After a month, we'll take it. You inform us about the proceedings of the Bar Council.
Otherwise, it is not the case of the petitioner that para 4 is not a part of the petition lordship. Para 4 lordship, if para 4 exists lordship, then something it will be difficult lordship to.
if required, my lord, we may be allowed to amend the paragraph 4, my lord.
No, let us see, we are issuing notice. We await the outcome of
Yes,
the progress of the complaint.
yes,
Then we'll see. But Mr. Yes, then senior counsel assisted by Mr. When you say yes, we will confirm the petitioner and also for the respondent. Next para. In this case, it is positive that because of the incorrect advice of the earlier conducting counsel, the petitioner, the applicant was misled and did not appear before the learned Foreigners Tribunal on remand of the matter by order dated 26/4/2023, passed by this court in WBC 943 of 2018. Next paragraph. The learned standing counsel for the border and active matters has opposed the prayer. Accordingly, it is submitted that the time as granted by the said order dated 26/4/2023 to appear before the Maharashtra Tribunal be extended. So the Maharashtra Tribunal for the border and active matters opposes the prayer. Next paragraph. As it is projected that a complaint before the Bar Council of Assam, Nagaland, etc. has been filed. So now, the court is in time to issue notice returnable on due date after 1 month. So without requiring any steps to be taken, just of how extra copies of the application be provided to the learned CGC State and Learned Council within 2 days. Next, the Learned Council for the petitioner shall apprise the court about the progress of the proceedings before the Bar Council of Assam, Nagaland, etc. Next, list on Spencer.
Deep lovely.
In fact, Mr. Sudhir,
Fine.
it is for these reasons now we have issued notice on both the bar associations to address the court as to why in all pending matters we should not give a general direction by virtue of judicial orders that the phone numbers or email addresses of all the litigants should not be brought on record. So every litigant will have to now file an supposing we pass orders, then every litigant will have to file their phone numbers and email addresses in all pending cases. This what you call applications of this sort has to be stopped.
Yes, my lord. This honorable court has rightly directed my lord to harness the phone number in the affidavit. That is a right step.
No, that is in the new cases, but
Right.
now in all
Case.
pending matters, we
Yes,
are
sir.
requiring that. We have issued notice. This
Right.
also has to be stopped.
Deep lovely.
Upgraded item 28 for orders.
That is referred. I have filed this, I have for extension of bail order, Malak. This petitioner, Malak, file a writ petition, Malak. Number 7279 of this is 2011, Malak. But on 13 March 2026, Malak, this honorable court was pleased to pass an order and granting bail, Malak, to the petitioner. Malak, page number, Malak, 810, Malak. Page number 9 and 10, Malak, para number 3, Malak. Thereafter, Malak, the petitioner appeared before the SP border Soraido, Malak, on 18 March 2026, Malak. Malak, as per this honorable High Court order, Malak, I appeared before the Foreigners Tribunal, Malak, on 27/5/2026, along with written statement and evidence of all witnesses. But the Learned Tribunal, Malak, Jorhat, has not accepted the written statement evidence without receipt of this appearance, Malak. It did not submit the receipt, Malak. Nobody gives you receipt. Your application itself does not appear to be correct. You see, in paragraph 4, what do you say? That you went to the superintendent of police, gave bail, and he did not give you any receipt of appearance. You don't get receipt of appearance. I have not seen in any bail granted that the court or the superintendent of police will give you a receipt of appearance. Did not issue my receipt, my lord. You will not get. You'll have to call for the records from the SP whether you have given bail or not. He will not give you a receipt. If he has taken bail, he'll get it recorded in the office. Mr. Sharma, can you find it out?
Whether he appeared or not.
He appeared and took bail or not?
Yes, sir.
You take it up on Friday then.
Yes, sir.
You give an extra copy of the application to him. Okay, ma'am. Mr. S. Islam, Learned Counsel for the applicant shall provide a copy of the interlocutory application to Mr. G. Sharma and its standing counsel for the border and active matters so as to enable him to obtain instructions as to the characters of statement made in paragraph 4 of this application that the applicant appeared before the Superintendent of Police border Soraidev on 18/3/2026 and took bail in respect of the applicant in terms of order dated 13/3/2026, passed in WBC 7279 of 2025. Next paragraph. That is standing counsel for the border and active matters is next paragraph. This is after one. Good Friday. 20. 31. 31/7/2026. SPL बनाए लिक्विडिटी भरे से लिक्विडिटी सब लगे मतलब लिक्विडिटी वैसे ठीक नहीं Mr. Sharma, please file out. Take it up Friday.
Yes, sir.
Item 29 for orders upgraded.
It please your lordship. There has crept in a delay of 75 days in filing the connection with the appeal lordship. Similar petitions are in fact coming up before this court on 30th of July, 31st of July. Writ appeal 19 193 of 26 and writ appeal 194 of 26.
Only state is there.
Lordship, Mr.
There's
Kogi.
there's no
appeared-
private respondents.
Yes.
There are no private respondents.
I'm so sorry to interrupt. I wasn't aware of this. I'm waiting for item 31, which is related to the review. I heard my name, so I just put on the mic, Lordship, Ladyship.
These matters are coming up on 31st of July, Manoj. 31st.
So we issue notice returnable on 31st. Okay.
That would be fair.
Heard. Ms. B. Chaudhary, London Senior Counsel, assisted by Ms. Imsen Kala. Learned counsel for the applicant. Also heard. Mr. N. Kohli, London Senior Counsel, assisted by
Mr. A. Roy and Miss Menon.
Ms. A. Roy and Ms. Menon, learned counsel for the applicants. Oh, sorry, respondent. Next slide. I just submitted that similar matters are stated to be listed on 31/7/2026. Issue notice on this interlocutory application filed under section 5 of the Limitation Act, by which the applicant pays for controlling the delay of 75 days beyond the period of limitation in filing the connected document. Next paragraph. Requisite extra copies of the interlocutory application and the connected memo of appeal be provided to the learned government advocate in within 2 days. Next paragraph. List also also 31/7.
Manoj, it can come up
Lordship-
with writ appeal 193. Writ appeal 193 of the 2026 is the lead matter in other matters, Manoj.
It's okay. It will come. We can take it up together.
Please,
Doesn't matter to us.
please.
If Lordship would permit me, since we are on the APSC batch, item 26 and 31 are the reviews filed by Lordship the State against para 67 and 68. Lordship, in this also in the connected matter, Lordship has already issued notice on 26th of May and it was listed, it is coming up on 31st. So if Lordship is pleased to again issue notice, that matter also would come up before Lordship on the 31st.
Okay.
Only one point I must assist Lordship is that in item 31, there is a delay and there's a condonation of delay of 66 days. In item 26, there is no delay.
Okay. We'll take up one by one. Item 26.
Yes, Lordship.
Okay. Give item 26. Mr. Kohli, those for the who appeared for the private respondent in this in the writ proceedings.
Well, Lordship, these are reviews. And that day,
No, because you'll have to take steps. Otherwise, you could have served notice on the lawyer and he would have.
yes,
appeared.
Lordship. Lordship may just issue notice and keep it on the 31st.
No, we'll have to take steps then.
Yes, of course, I understand, Lordship. So even in the other order, Lordship, which is actually in both orders, like Pallavi Sharma also, we were not there. 26/5 in review petition 64, Lordship issued notice.
If somebody appeared, then there is no problem, but.
There is no one Lordship who appeared.
But in
No.
this case, if you don't, you did not disclose the name of the lawyer, did not give him copies, his mandate would continue.
Actually, Lordship, on the last order, Lordship has written in the other petition, review petition, the appellant shall take steps for service of notice on respondent by speed post and AD.
Then you have to give that only. But this will go to a different date then. Notice has to be served.
Yes, of course, Lordship. I understand. That is fair, Lordship.
In this item 26. Heard Mr. M. Kohli, Senior Counsel, assisted by Mr. A. Roy and Ms. N. Menon, learned counsel for the appellants. Next paragraph. Issue notice on this review petition, returnable on, give a date after 4 weeks, returnable on so and so. Next paragraph, the appellants shall take steps within 2 days for service of notice on the respondent by speed post with AD. Next paragraph, the learned instructing counsel for the appellant is at liberty to collect the postal receipt number and to submit postal track report prior to the next date of listing.
It is only para 67 and 68, Lordship.
That's okay. We remember that you made a submission earlier.
Grateful, Lordship. Lordship, maybe 30, if 31st or 1st of 31st August or 1st of September, if it's convenient to Lordship.
No, but you have to serve. Will
We'll
you do
serve.
it by Dusty? You'll do it by Dusty then?
Yes, Lordship, we'll have it done.
Okay. Then make it 31st.
Grateful, Lordship.
31st of August.
Yes, Lordship.
Okay, 31st of August. In addition to usual steps, in addition to steps by speed post, the appellant is at liberty to, the appellant shall take steps for service of notice of the respondent by Dusty mode and to file an affidavit of service prior to the next date of listing. That's why list one 31/8/2026. Then what is the next item?
Item 31, Lordship.
31. This is a delay.
Yes, Lordship. That's why I said it's 66 days.
How many days? Delay?
66 days, Lordship.
66 days. Okay. That's correct. You should notice on this application, final section 5 of the Limitation Act for considering the delay of 66 days beyond the period of limitation in filing the connected appeal. Next one, issue notice returnable on 31/8/2026. Next one, the applicant shall take steps within 2 days for service of notice on the respondent by speed post with AD. Learning counsel for the learning instructing counsel shall for the applicant is at liberty to collect the postal receipt number and submit postal track report prior to the next date of listing. Next paragraph. In addition, the applicant is permitted to serve notice on the respondent by Dusty mode and to file an affidavit of service prior to the next date of listing. Next paragraph. This terms consent. Yes.
I'm so deeply obliged.
Only 2 matters.
Only 2 matters, Lordship.
Okay.
31st is a heavy day.
Okay.
Grateful, Lordship. Ladyship.
Upgraded item for orders. Item 30.
There is 2 days delay, madam. So preferring the appeal, madam. Is the appeal preferred by Bank of Maharashtra. And the judgment was passed on 15/5/2026, and the appeal was filed on 18/6/2026. There's only 2 days delay of it.
You are appealing for the respondent. Any objection? Any objection?
No objection.
Okay. Heard Mr. A. Kharikan, counsel for the applicant. Also heard Mr. A. Dhanuka, learned counsel appearing for the respondents. Next para. By filing this application under Section 5 of the Limitation Act, the applicant is paid for conveyance a delay of 2 days beyond the period of limitation in filing the connected appeal. Next para. The learned counsel for the respondents has opposed the prayer. Next para. Nonetheless, having regard to the nature of explanation tendered, the same is accepted as a good and sufficient cause for cause which prevented the applicant from filing the connected appeal on time. So accordingly, the delay of 2 days in presenting the connected appeal stands condoned. Next time, the registry shall now register the connected appeal and list the same in the admission column.
Deep look.
But giving copies,
But no, I have already given copy everything.
For admission, item 6.
Notice, my lord, in this case, my lord, record already been received, my lord, matter may fix for hearing, my lord.
we will take up matters. These are 22 matters. We'll take it up for hearing.
My lord, in this case, my lord, petitioner being a lady, my lord, she enrolled her name in the voter list of 1989, my lord. To my lord, to prove her citizenship, my lord, she exhibited some voter list, my lord, in respect of his parents, my lord. To for that 1965, my lord, where my lord, petitioner's father name and his paternal uncle name appear, my lord. In subsequent voter list also 1997, my lord,
Just a moment. Which is the voters list?
1965, my lord, page 25, my lord.
The father's voter list is of which year?
Yeah, my lord. 1965 voter list.
Which page is that?
Page 25, my lord.
25. Where is your written statement?
My lord.
In your written statement, you have not disclosed the name of your father.
My lord, but it was only stated that, my lord, his father's name appeared in the voter list. There has been stated. My lord. In the second line of vernacular, my lord, it is written that Mohammed আদালত উক্ত গোচরের অপরপক্ষ মোহাম্মদ ফজলা খাতুন ওরফে ফজলা পিতা মৃত্যু ময়জুদ্দিন স্বামী নুর ইসলাম।
Due to your projected parents, there's some discrepancy which may not be so material, but still there is a discrepancy. You say your father died on 16/1/2006. According to your uncle, your father died 7 years back, 7 years prior to 2018. It will come to 2011. There is 5 year difference.
Yes, ma'am. That means my uncle, at the 11th part of my uncle is 80 years old. So might be that he is due to the old
So
age.
80 years at all times may not be wrong. I had the fortune of meeting a lawyer at the age of 92 in the court and discussed matters with him.
That may not be married, but may not, due to the age may not, sometimes may not.
It's not a case of sometimes. You have brought your witness of your own volition. We say that it's not material, but except for that, there's no other document. In your written statement, you say that you're filing your father's death certificate. That was not filed. Then your father's voting is 66 and 70.
Yes.
And even if he died in 2006, there's no voters list in between. There's no connect. There's no other document exhibited.
My lord, the petitioners exhibited those two documents. Those two documents also exhibited by the DW2 my lord. Those two documents exhibited only to prove the existence of his father, my lord. And the subsequent
Exchange, his father is not present from 1970 to 2006. He's not present.
Petitioner's uncle names appear along with father, my lord, both voter list.
Hmm?
Petitioner's uncle's name appear along with petitioner's father, my lord.
Those were not exhibited.
Why exhibited by DW2, my lord?
DW2,
Yes, my lord.
he is exhibited.
Yes, my lord.
What is the 1965,
1965 and 1970, both.
1970?
Yes, my
So
lord.
after 70 till 2018, his presence is also not there.
There is also another voter list, my lord, which is in certificate copy issued to the petitioner, my lord. That is to retain as exhibit, my lord, but no mark, my lord. There is a 1989 voter list, my lord, in respect of the petitioner, my lord. My lord, considering the, my lord, evidence of the, my lord, DW2, my lord, he, my lord, categorically deposed that, my lord, petitioner is the daughter of his younger brother, my lord. So, my lord, petitioner may declare, my lord, India, my lord. What is the from this particular? No, my lord.
Okay. My humble submission is that Lordship, there is no infirmity in the opinion passed by the learned tribunal, and Lordship, here Lordship, WS is totally vague, Lordship. In this regard, Lordship, Lordship, I want to rely 2017 to GLT 1076, Lordship. 2017 to GLT 1076. Momin Ali, MOMIN, Momin Ali versus Union of India, para 12, 13, and 17, Lordship. Just I am reading, Lordship, para 12. This written statement of the petitioner is solely inadequate and did not disclose any material facts. As noticed above, it was allegation of the state that the petitioner was foreigner. Therefore, as per mandate of Section 9 of the Foreigners Act 1946, it was the bounden duty of the petitioner to have disclosed all material facts which are specifically within his knowledge in the written statement, but he did not do so. Petitioner neither mentioned his date of birth nor his age. He was silent regarding the name of his mother and identity of his grandparents, both paternal and maternal. He did not mention anything about his brothers and sisters or about his marital status. On the basis of such written statement, it cannot be said that the petitioner had stated anything substantial to show that he was not a foreigner but a citizen of India. It is a settled, para 13 lordship, it is a settled position of law that where a party fails to set up a case in his pleadings, he would be debarred from adducing evidence in his support at this stage of trial. As a matter of principle, variance between pleadings and proof is not permissible. And then lordship, para 17, reverting back to the written statement, it has already been noticed that there was not a whisper by the petitioner that he had any brothers or sister, not to speak of disclosing their names and other particulars. Therefore, sudden appearance of Umar Ali in the witness box as brother of the petitioner has to be looked with suspicion, and his suspicion is further fortified by the fact that in the 1997 voter list, name of Umar Ali did not appear along with the petitioner. That apart, so lordship, here in this case, lordship, written statement is totally vague and nothing said about his parents, lordship, about his uncle's lordship. So, and what document exhibited by the proceedee is lordship, only the projected uncle of the proceedee lordship, he exhibited those documents. Petitioner has not exhibited those documents. Apart from that lordship, petitioner nowhere disclosed about her paternal uncle lordship. So his evidence may not be taken into consideration lordship. And apart from that lordship, this evidence, this deposition lordship, his statements and statement of the proceedee lordship, it contradicts each other lordship. So lordship, his evidence will not help the proceedee to confirm his citizenship lordship. So apart from that lordship, after 1970 lordship, there is not a single voter list has been placed lordship in respect of his family lordship, projected family lordship. So lordship, apart from that lordship, I think there is nothing to say, nothing more to say lordship. And it is settled position of law that lordship oral statement is not enough to prove one citizenship lordship. So many settled laws are there lordship in respect of this lordship. So lordship, this is my humble submission lordship.
Though my lord, the written statement is a very, my lord, only a small written statement, my lord. But then also, my lord, she categorically stated that, my lord, her father's name appeared in the voter list of 1966, 66 and 1970, my lord. My lord, and in the said voter list, my lord, though exhibited by the DW2, my lord, where, my lord, along with his father, my lord, her uncle's name will appear, my lord. Though, my lord, it was not mentioned her the uncle number in the written statement as well as the inner evidence in sheet, my lord. Then also, my lord, the sheet say two documents, my lord. It's a where categorically shows that, my lord, our father's name and his uncle name, my lord. Against them, my lord, his grandfather name appear. So, my lord, it can be logically concluded that, my lord, he is the uncle of the petitioner, my lord. And he deposed before he was the UWP is 80 years old, my lord. He deposed before the tribunal, my lord. He categorically stated that the petitioner is his, my lord, sister of his younger brother, my lord. So, my lord, considering that part, my lord, On especially the materials available on record. Found the evidence of the DWs untrustworthy. And the impugn opinion was passed on arriving at a conclusion that the petitioner has not produced any other reliable and trustworthy documents. And or reliable over evidence to prove that her parents and grandparents existed in the Indian soil prior to 25/3/1971. To stop. Exhibit 1 and 2 were discarded as the petitioner did not prove that she is the daughter of Moizuddin. And exhibit 1 and exhibit 2 were found unacceptable and unreliable. That's correct. No, not as para, same para. So moreover, comma, the Yes, ma'am.
My lord.
It was issued on 31/10/2019. 17 and 19. 17, my lord. My lord.
Just like seven, it should be seven, or
17.
Assam is seven.
17.
Yes, yes. Okay.
But it is certified to be true copy on 8/8/2018. No, my lord, no, sorry, my lord, sorry. That's 31/10/2017. Issued on 27/3/2018. Yes, my lord.
Establishment. Item 7 for admission.
May I please, Your Lordship, respectfully pray that this matter may kindly be adjourned for today. And adjourn for today. RM Lamin. Lamin.
For admission, item 8.
Made, please, Your Lordship. This is an appeal preferred by the state, my lord. This is intra-court appeal challenging the order dated 17/11/2021, passed in WPC 3816/2021, my lord. Whereby, my lord, Honorable single judge has interfered with a notification which was not under challenge, my lord. Prayer, my lord, will find at page 64, my lord. Impugn order is 2010-2020, well, that my lord will find at page 165. This is basically communication, my lord. Page 165. They are basically agreed by the third paragraph, my lord. Sorry, my lord. Yes, my lord. Yes, my lord. Well, earlier, cabinet decision was taken in the year 2016, my lord. Thereafter, OM was published, my lord. But during the interim period, my lord, the Act of 2017 was enacted. Now, my lord, all provincial matters are governed by the statutory scheme, my lord. That was an executive instruction, but subsequently, while before issuance of the final order of provincialization, the Act of 2017 has been enacted. So now the entire scheme of provincialization is governed by a statutory scheme, my lord. So that is why, my lord, subsequently, we have decided that their case also will be considered under the 2017 Act. Yes. Cabinet has taken a decision, but that was not implemented. And during the period, my lord, the new act has come, which now govern the field, my lord.
This is a very unfortunate case. Because Lordship so permits, I'll just quickly indicate. In fact, my lord, there was a fault on this side also. There was an act of 1996. Under that, 48 colleges were provincialized. We, most of us, we are a total of around 42 petitioners. 35 of them were under the 96 Act. And Section 3, if your lordship will just permit me. Now they are talking about some cabinet decision and what's not. Just one, if your lordship allows me 1 minute time. 96 Act. It has been notified.
OM was issued, my lord. OM was
Yes,
issued.
yes,
OM
it
was
was
issued.
notified. That is why the learned signature took note of that. Then how can a cabinet decision be overturned by an undated notification issued by the secretary? In fact, my lord, even besides that, your lordship will just have a look at section 3 only. Beyond that, I will not trouble you. Now they are talking about some cabinet decision, executive instruction. Your lordship will just have a look at section 3. I don't know why this point was never argued. This is under the law we were entitled to. Just have a look at section 3. It is a deeming provision. '96 Act, and these colleges were provincialized. There is a deeming provision. So it is automatic. In 1996, something that was the legislature gave us automatically. They kept dragging it for decades, not years. And now they want to say that we will fall under the 2017 Act. How can it be permitted? If your lordship is aware, a right is conferred under an act, even if that act is repealed, that right will have to be given. Yes, exactly. So that is the sad part. Since 1996, these people, we are in 2020, 3 decades. And that is why the learned signature issues a direction. In the last paragraph, your lordship will see what is the direction. paragraph 13. We have taken note that in the meantime, some of the petitioners are approaching the date of retirement in the month of December 2021. Yeah, such view, the requirement of bringing the process to its logical conclusion within November 22. And we are now in 2024. Many have retired without getting me. 3 decades. May I make a small prayer? Today I can understand the time constraint. If it is not inconvenient to your lordship, but if this can be kept as a part head and top of the list, let lordship has seen how at least 7-8 rounds of litigation, and in spite of that, we are there in this kind of a situation. If your lordship as a special consideration, if your lordship takes up this matter maybe Thursday. I myself find it difficult. I normally don't, I myself enjoy putting pressure on your lordship. But there are some cases where we also feel guilty as well. After 4. After 4. Sorry, open. Six a bit more. 6, I will be in it. Can it be 11th? 11th or 13th, whichever date is convenient to you. Right.
Item 12. I appear, my lord.
We have filed affidavit today. We have filed affidavit. The thing is not on record.
Sorry, mata lage I'm excited.
Item number 11, my lord, they have to, nobody filed affidavit till today, but it has to be filed before 7th of August, my lord.
Lordship, I'm
Yeah, the
appearing for NHA. I'll be filing it.
My lord. 12.
I know that. My lordship, today itself we have filed, let it be day after tomorrow. Today, lordship. Already.
my lord, can it be on another date, my lord? I appear for CGC, my lord. Can it be after or, my lord, day after? My lord, can it be on? If it pleases my lord only, can it be on 7th of August? I would like to file a rejoinder to what the opposition have filed. Two affidavits are there actually, my lord. If it pleases my lord only. দুটা আছে CGCO ফাইল কৰিছে আপোনালোকো ফাইল কৰিছে তোমালোকক কপি দিলে ফাইল কৰিছা DPO 7.
May it please the lordship. May it please the lordship, my lord, in respect to item number 16, it's a fresh file.
In compliance with the order, till today, no affidavit has been filed by any of the respondents. I'm appearing for the NHA, that's respondent number 19, lordship. I'll be filing in a week time, lordship. Very calm. আমার ডিটেক্টর লিখনি অ্যাটলি কাজ না ওইখানে মানে দিতে বসছি না তখন বসে দেখছি এটা তো অনেক হইলেও বিশাল লিস্ট নিয়ে কিছু না এটা তো সামনে কারণ পকেটে কাজ 1 2 3 4 9 17 18 19 perfect 19 possibly 17 one they have bounded bar they are normal sometimes 13 22 20 21 okay. For state of Assam, I am appearing. I have a similar prayer, lordship. I also pray for 183. Respondent number 1, 5, 9, 13, 20, and 21. 9, 13, 20, 21. 20 and 21. Mother.
Lordship, the names are not reflected in the court list, lordship. I think they have missed that one.
Otherwise, the state of Nagaland, they will represent respondent number 2, 6, 10, 14, 22, 2, 6, 10, 14, 14, 22, 23, and 24. 20. I have said. Respondent number 3, 7, 11, 15, and 25. 7, 11, 15, and 25. 25. And Arunachal also, my lord, they are accepting, my lord, 48.
Lordship, response number 4,
8,
8,
12,
16, four, Lordship, 8, 12, 16, 26, and 27.
Malo. Malo, I prefer one is time.
And central government also represent ballot. SK maybe. You're
I'm for NHL,
no, it's the number.
18 and 19. I'm for NHL. I'm seeking 1 week's time, Lordship. I'll file. Devojit Borkakoti. Borkakoti. Nineteen. My instructions are from 19. Regional office. Lordship. 20 somebody else.
20 I may very much. No, 20 is PWD NHA, State of Assam.
17, 18, 19, it was accepted by the central government, my lord, SK maybe. Oh, my lord, sorry. My lord.
Borkakoti.
Sorry. Mr. SK maybe.
Your
17.
no. 18, 19 is appearing.
Okay, my instructions are from me.
Respondent number 9, Housing and Urban Affairs is there, no? Respondent number 9, Housing and Urban Affairs is there. State of Assam.
That is by the aspect of
Sorry. Municipal. It is not there.
They make categories for the.
Hello.
Municipal is not, no?
Commissioner and Secretary, the Government of Assam, Housing and Urban Development from that meeting.
Municipal administration is a different.
Different.
It's an independent body.
Urban bodies are looked up by these. But the response number 13, Panchayat and Rural Development Department is made party. We have all municipal,
My lord.
lot,
As per the direction.
mal,
Yes, ma'am.
lot.
They are not parties to that.
No. Mal,
My lord.
you can have it.
Direction, Secretary level.
My lord.
Page 8. My lord. Yes, no, municipal, that should be direction. Municipal authority is not made party, my lord, here. Not party, panchayat is there. Because that direct. Aye. Yes. Aye. The railway authority having jurisdiction over railway station. The municipal and my lord. My lord.
Milord is reading which order of the Supreme Court? This is last year's or this?
No, no, there are 3 orders. Yes. Yes, the first is this court. That Supreme Court order, that is, my lord, they are, here, page 58, my lord. Page 58.
11.
Page 58. E&E. Aye. Yes. 60I, the municipal authority shall file an affidavit compliance with the complete statistics. Yes. My lord. Not through the correction, direction to petition. Yes, ma'am. Yes.
The names are not in the hot list.
Yes, and then you go over the page. Page four. He is also referred to DSI. Radio opposite and direction center. This is from 11. This is from 11 18. August 22. August 22. August 22, August 2023. There are 32. There are 32. Okay. B, 33D. Railway also supplementary land. Railway also. Union of Individual Affairs, it is there. But affidavit has to be filed by page 222 minus 222, page 222.
The direction starts from 212.
But it is relevant page 222, my lord. When on or before 7th, respective High Court, before the respondent, my lord, they have to file affidavit on or before 7th August 2020. Page 222. E. Direction E. Legally, এখানে আমার হাসতে হচ্ছে রাস্তা না the name of the council. The council. So the
Senior government.
পানি চলে সব করলে সে এটা মনে হয় খুব আনা পহিলা বস্তু
7th of August, let's say? Yes. Can it be 12, let's say? We'll be filing it before that. No, no, no. Not at all.
Well,
That's it.
Deep.
Much obliged.
Let me just, I'm sorry, my lord. When item number 19, my lord, it was very urgent matter, my lord. Okay. Okay.
My previous option, my lord. My lord, the respondent has filed an affidavit, my lord, objection affidavit. My lord, making some, my lord, allegation and also on the basis of certain documents. So, my lord, I am not aware of these documents. I also couldn't contact my client, possibly, my lord, due to some flood problem, my lord, in North Lakhimpur.
There is no flood in not looking.
So I need, my lord, takes time to file affidavit, objection, man, affidavit reply.
Hello, if your lordships allows me to say 5 minutes, my lord, speak for 5 minutes, I'll show this is the whole process has been initiated, is a misuse of the process of the court after the mediation order.
These documents,
My
sir,
lord,
for the first time, my lord, has come to my
no,
notice.
I'm just pointing out, my lord, your lordship will kindly see. Kindly see, my lord, page 54 of the review petition. Page 54 of the review petition. No, 58 of the review petition.
No, Mr. Das, you have filed an affidavit on 26/7.
Yes.
Respond to it.
Let him respond, but otherwise, my lord, on the face of it, I can show you before lordship, this is the whole process has been misuse of the process of the court, my lord.
No, we understand.
After the mediation order.
But can we stop reply to be filed? That is the
No,
problem.
this cannot be, if your lordship is, if I can convince your lordship, and let him take the time, but whole process, well, it's a total misrepresentation before the court also. Their main grievance was as regards Schedule B. So therefore, your lordship by an interim order granted injunction in respect of Schedule B property. Now in mediation also, they did not raise this, it was understanding that C, D, E property one doesn't belong to deponent's father, not the father-in-law of the petitioner.
I will
No, please let him complete. Let him
But
complete.
yes, and how can a mediation order be challenged in this manner? It's a complete process, misuse of the process of the court. Let him file affidavit. I don't want any matter to go just like that, man.
Yeah, I understand. But
on the face of the record, it's not maintainable, my lord, even if it is mediation order is not there. But having gone through the mediation, some process have been followed. After that, my lord, they cannot take this kind of plea, my lord, which was not there.
kindly shows the earlier order which permitted this mediation.
My lord, your lordship will kindly see regarding injunction order, page
No, that
50,
mediation. Order
58.
of mediation.
Mediation order is at your lordship's last order is at page 87, and the mediation order is. They have not annexed. They have not annexed it here. Otherwise, your lordship has passed this order. Mediation order is there.
Okay, so there was a mediation, and therefore, thereafter this court accepted that and made it a part of the
Accordingly,
mediation order, page
yes.
66.
Yes, ma'am. Yes. Accordingly, decree has been passed.
And now what is the prayer?
And the title suit has been dismissed, my lord. Suit has been dismissed in the year 2022.
And where is the prayer in this review petition?
Review petition is that prayer, page 48.
Okay, I get it now.
Elevation is mediation. In law, elevation.
And this,
And page 58, your lordship will get that injunction order. That is in respect of schedule B problem. 58 last, para 11. In the interim, this court inclined to grant temporary. B has been already partitioned between the petitioner and the present deponent and another brother, my lord. And C, D, E property doesn't belong to petitioner, my lord. The petitioner's father.
and where's the mediation order?
Mediation order is at
66.
Type copy is 68. Is it that?
68. Yes, my lord. Yes, sir.
This was on 10/9/18.
Then I get it.
All have signed.
All have signed.
No, it's
And
okay.
rule 5.
No, not that. I'm looking
Yes,
at
ma'am.
something else.
Yes, yes.
It is 10/9/18.
18.
And the High Court order to accept that is at page 64.
Page 64, yes, ma'am.
Page 64.
Starts from page 66, madam. And accordingly, decree has been passed,
Yes,
madam.
just a moment.
Madam.
I'm just making notes so that on next
Madam,
day, it will be easier for me to handle it.
But I'm surprised, my lord, the thing has not been put in order, my lord. They came for different purpose. Now, mediation has been questioned on different purpose, madam.
15/9/18.
And the suit has been dismissed on 17/2/22. The lordship may kindly record, madam. I can give a copy. Now, after the disposal of the suit, what is there? You are not interested in other properties. And in our objections, we have already, my lord, shown in paragraph 3, 4, 5, and 6 why this proper schedule C, D, and E, my lord, cannot be subject matter of mediation.
This
And this is
this
in
order,
objection.
just a moment. This order of mediation
Yes.
was passed by this court or by the trial court? I think
No,
by
you're this
court.
court.
By
This
this
court.
court only. Okay.
And in my objection petition we have filed, there we have shown why C, D, and E is not a subject matter of mediation. Even if it goes to mediation, what will happen? Nothing is going to happen. We will not accept it. And it is known to the petitioner, my lord.
Has the decree been drawn up and sent for
Yes,
execution?
yes, madam. Decree been drawn up. Madam.
Decree drawn up.
Drawn up.
Has it been sent for execution?
Execution, my lord, it is amicably settled. Execution, amicably already divided properties. Madam.
Okay.
It is just a formality. After the mediation order, property has been divided.
And
And
Mr. Prakash, sir, what is?
Suit was dismissed on 17/2/22. madam. 72 suit was. So that shows that they are not interested. How can they matter?
On? So dismissed on?
17/2/22.
Okay. And Mr. Prakash, sir,
My lord.
why you need the, why you are praying for a mediation, sorry, rehearing again?
Hearing,
On what?
because my lord, as I am, my lord, instructed by my client that property, my lord, schedule C, D, and E, they have their share. And they are now saying, my lord, there are certain documents which will show that property C schedule stands in the name of the original, my lord, father-in-law of the petitioner. There is the original Khagendra, my lord, Chankakuti. Therefore, it cannot go, my lord, to the respondent alone. Record shows, according to them, I have some telephonic, you know, talk, and they say that there are some documents, Jamabandi shows that property stands in the name of my lord Khagendra. Therefore, if it is so, my lord, then property cannot be inherited by him. The respondent alone.
We have not inherited property.
Mala,
We have not.
whether that part of the facts is factually correct or not, my lord, almost until I get the copy, my lord. And cinema, so far as cinema is concerned, schedule E is concerned, my lord, that property was run by my lord deceased husband of the petitioner at one point of time.
Lease.
And it was the property run by their, my lord, original ancestor, Khagendra Chankakuti. Therefore, whatever income is arriving, my lord, deriving, my lord, my client may have some share. That is their say. Therefore, unless and until I get some, my lord, proper instruction and relevant documents.
We are giving you 1 week's time to file affidavit.
My lord, 2 weeks time, my lord.
No.
By a flood affected area, my lord, they are not in a position to come.
This is not a flood affected area. My lord.
2019 review, you get it within a week.
My lord, then 10 days, my lord,
Okay, 10 days.
Otherwise, my lord, I may not be able.
You will be able to. Now is what you call, we all are tech savvy and you are more faster.
Mr. Purkasta is more faster, far more faster.
Yes.
He will not spare me.
Mr. B. Purkasta, Sorry, Mr. A.K. Prokasal and counsel for the petitioner raised for and is granted 10 days time to file the affidavit in reply to the affidavit in opposition filed by the respondents. Next para, Mr. B.D. Das, the senior counsel, assisted by Mr. S.K. Sharma, and counsel for the respondent is present. The respondents is present. Next para. Affidavit shall be filed by 6/8/2026. Next para, this on 10/8/2026.
10. May I request a lordship, my lord, instead of 10, can it be fixed on 12?
12.
My lord, if otherwise convenient.
No, every day is convenient for us. Okay, 12th,
My lord, our bless.
but you have to file your affidavit by 6.
By 6. We have 6.
Just before that, you say that the matter would not be adjourned on the next date of this.
My lord.
Deeply obliged, my lord.